Hi, everyone, and thank you for joining all of us at Work Comp in Motion for today's webinar themed The Fee Schedule Survival Kit. We're very excited about today's presentation as Work Comp in Motion has assembled two subject matter experts to help equip us for the newly adopted changes. For those of you that don't know who I am, my name is Carlos Luna, Vice President of Marketing for Risico, a Fresno-based workers' compensation third-party administration company, managed care organization, and insurance provider. I have the pleasure of being your host for the day. Now, Workers' Comp in Motion would like to give a great big thank you to our sponsors for today's webinar. They are Siegel, Moreno, and Stetler, Institutes of Health, NewQuest, Claim Logics, MacroPro, ProCare, GenX, Corvell, iRatings, Learning Services in partnership with Remed, Ember Court Reporters, Dental Works, California Orthopedic Institute, Optum, MedRisk, Merge Investigations, and of course, Risico. Please be advised that CEU credits will be provided to all California claim adjusters, and we'll be announcing raffle winners following the presentation today. So you'll want to stick around to see if you won a prize. Please be advised also that we've allocated time at the conclusion of the presentation for questions from the audience. And if you'd like to ask a question of the panel today, please type it into the chat box into the bottom left-hand corner of your screen and click enter. Now, you're all in for a very insightful presentation on California's new med legal fee schedule. In just a moment, you're going to hear from two of the brightest minds in California's workers' comp defense legal affairs. I've asked each of them to tell us a little bit about themselves. So, without further delay, please help me welcome Josh Goldsmith and Phil Hermanson. Gentlemen.
Hi, for those of you who don't know me, my name is Joshua Goldsmith. I'm a partner at San Diego's Siegel, Moreno, and Stetler office. I cannot vouch for the level of expertise that Carlos has stated about myself, but hopefully I can take you through this without boring you too much. I told Jen yesterday, if we run quick and we run out of topics to talk about, maybe I'll just pull out a guitar and play for a few minutes or something to try and make this a little breezier. It's definitely not the most fascinating of topics. For those of you who don't know me, I grew up in Kentucky. I've been practicing workers' comp for about 15 years. The first few of those were in Ohio, where I went to law school at the University of Cincinnati. And then I came out here and was an applicant's attorney in San Diego, handling basically only sports law cases for retired professional athletes. And since then, I've worked for Siegel, Moreno, and Stetler for the last 7 years on the defense side. I started out actually with a fellowship in international human rights when I went to law school and worked for an environmental NGO in Thailand. So definitely not in Kansas anymore in terms of what I'm actually ended up doing for a living. So anyway, we're going to talk about the med legal fee schedule today. And probably a lot of you have never really dealt with the med legal fee schedule before. You just kind of know, oh, I get charged a certain amount and I kick the report over to bill review and they produce an EOR. And unless I end up in some kind of weird non-IBR fight about med legal costs, you probably haven't paid that much attention to it. But you might want to start paying attention to it given some of the recent changes. Now, to give you a sense of how the fee schedule worked before, there's a California Code of Regs. It's section 9793, 94, and 95 that basically lay out how you're going to charge for med legal reporting. And previously, there were a few billing codes. There was ML 102, which was basically for the most basic med legal evaluation. I almost never saw any med legal physicians actually bill a 102. And that was $625. And then there was an ML 103, and that was $975. And then there was an ML 104, which was billed at $250 an hour. And there were things called complexity factors on a case, basically, whether you had to address how many body parts you had to address, whether you were addressing apportionment between multiple dates of injury, how many hours of records you had to review, that basically allowed you to take it from a 102 to a 103 to a 104. And then there was also an additional modifier where the price went up by 25% if it was an AME. So it would go from being $250 an hour to $312.50 an hour. And generally, that had been in place for about as long as I've been a defense attorney and some while before that. So I don't think there had been much changes in the cost of those reports for some time. So it wasn't a particular surprise that the DIR might want to increase that to some degree. The issues that are coming out now, as you'll see, is they've gotten rid of the complexity factors. And they've made a couple of aggressive changes into terms of how records are reviewed and the charges for that, which can significantly change the way you might want to conduct discovery on a case. So this went into effect on April 1st, 2021. You can skip to the next slide, Jen. And so what the DWC wanted to do is they wanted to put a flat fee system into place because apparently they had seen a pretty large increase in the amount of ML 104 reports where they were allowed to bill on an hourly rate and a significant increase in those costs. And so they thought maybe adopting a flat fee would prevent some of the potential abuses on that front. I'm sure everybody's seen a report where there was significant amounts of legal research or medical research that was done by a doctor, which had by and large been cut and pasted from every other report. And then that was billed at however many hours of research for the case, which allowed it to move up to an ML 104. And so I think that part of the issue was to try and prevent some of those abuses. They also thought that this could potentially attract new physicians to the system if there was a larger flat fee amount that you could sort of advertise up front for med legals. There are a lot of specialties in California where if you are submitting for a doctor, it may just come back and they say, sorry, we don't even have enough to fulfill that request. I think rheumatology is particularly difficult. I recently submitted one for an ophthalmologist. And even though I had previously gotten an ophthalmology panel just a few weeks ago, I got a letter on that case from the medical unit saying that there weren't enough physicians to provide a panel. So I think there has definitely been some aim to attract new physicians to the system so that some of these more obscure specialties have more doctors in them, and also for certain specialties so you don't see the same physicians over and over again. I know in particular with pulmonology in Southern California, I think I see the same 3 to 4 physicians, and it may even just be 3 at this point that are on every panel. So you kind of already know what doctor you're going to end up with a lot of times if you request pulmonology on a panel. That's one in particular where I know the list of doctors is very short for this area. Anyway, we can move on to the next slide. So here's how the new fee schedule works. It essentially replaces the prior ability to bill by the hour on an ML 104 with a flat fee. And as part of that flat fee, doctors are expected to review up to 200 pages of medical records. Now, as you know, on a lot of these cases, that's not very many. If you've had a case that's been open for a year or two, you might already have over 1,000 pages of medical records that are pertinent to your particular case that are treating physician records. And it's very hard to get around sending those to a doctor for review. But also, you may have thousands of pages of records that you've subpoenaed from Kaiser or applicant's treating hospital. And you're often going to submit those to secure your apportionment, to make sure the doctor's aware of prior injuries and complaints. And there is a now $3 per page charge for every page that you submit to the doctor that's over 200 pages. And that's where this really starts to get problematic in terms of increasing case costs and, in my opinion, potential litigation that you could see about what's a relevant medical record to submit to a doctor. Oftentimes, it made sense before to just submit all of your subpoenaed records and everything that would happen in the case and have the doctors review that and essentially decide what was relevant or irrelevant, because it was cheaper to do that than it was to pay your attorney who is on the file to actually sort through all the records and pick those out. But now that's simply not the case. It's going to be very hard to justify sending 15,000 pages of records to a doctor, because that'd be $45,000 for a record review at that point. So you're going to have to be significantly more careful about what records you're choosing to send to the doctor. Additionally, the fee schedule eliminates charges for those complex cases. So essentially, the flat fee is the same for every case, no matter how many body parts are being evaluated or the apportionment that's involved. So those complexity factors for the amount of body parts and prior injuries and apportionment no longer exist. It also established new rates for med-legal testimony, as well as different rates for Subrosa films, and Phil will go into some of those specific numbers later. There's also an increase in the amount of the AME modifier cost from 25% to 35%. That in particular doesn't really make sense to me, because I know in general judges like to encourage AMEs because it discourages litigation. And so by making that more expensive, I feel like people are going to be even less apt to agree to an AME. So that change in particular didn't quite make sense to me. It also establishes increased modifiers for psychiatric, psychological, toxicology, and oncological examinations. Now, the big ones there are obviously the psychiatric and the psychological, because those come up significantly more often than the other two. There's a decent amount of skin cancer med-legal evaluations that take place, especially if you handle much in the way of safety officer cases. Those get filed a lot more in those type of cases. I have been doing this for a lot of years, and I've handled at least 2,000 cases, and I've never seen a toxicological panel. So that one in particular, I'm just not sure that one's going to come up a lot. So that one's probably less relevant. Now, the thing that was kind of interesting about all of these changes is they kind of got dropped last minute, or at least it seemed that way to us. I think the first email that I saw that kind of discussed these changes coming down the line, for me, I saw early to mid-March, and they went into effect April 1st. And so when I saw it, I immediately read the part about the record reviews at $3 a page and kind of did a double take, and I emailed that out to everybody else at the firm and said, hey, is this serious? Like, is this a real thing that's going to be happening? And it did, and it did go into effect April 1st, and there was no grace period. There wasn't a lot of notification, at least as far as I knew out there amongst the legal community, that this was happening. And so I knew about the changes to the fee schedule. I actually wasn't, or had not dug into it enough to realize the declaration requirements, because essentially what we have to do is we have to send a declaration to the doctors with the amount of pages that we're sending to them, so they know how much to bill for, so they don't just get to count themselves and say, oh, I billed for 2,000 pages. We sign a under penalty of perjury declaration of the amount of pages that we were sending over. And we also have to verify that we went through the proper ex parte communication process in reaching an agreement on what records were going to be sent over to the doctor with the other side. Now, I had doctors immediately calling me up for panel exams that were scheduled April 1st and 2nd saying, where's my declaration? And at first I thought, I'm not signing that under penalty of perjury. And then I pulled out the new regs and I read them and I said, oh, crap, I've got to sign a declaration under penalty of perjury about this stuff. And was immediately, for all the panel examinations I had in the first 2 weeks of April, my assistant and I were scrambling to get this into place. I also realized that on some of these evaluations, we had sent over 3,000 pages of records. And so I had to talk to the clients and say, are you aware that this is happening? Are you still okay with the amount of records that we have sent over? What do you want to do in this case? So it created a lot of problems given the last minute nature of some of these changes. Generally, at this point, most of the examinations have probably already fallen into the new pattern that you're going to have in terms of these evaluations. probably the declarations are in place on those. But if they're not, make sure that you get those over to the doctors with a sufficient amount of time, because what we've seen is that doctors are essentially not agreeing to review any of the records, which they're not allowed to do. They're considered to be unavailable to them until they receive these declarations. And so they'll issue the initial report and then say they'll come back and issue a supplemental report later in time reviewing those records. Well, that means you could potentially get charged for those additional 200 pages because they weren't available at the time of the initial evaluation. So it's something that you want to make sure is in place on all of your cases. All right, next slide. All right, so just a few more details. Yeah, you'll probably cry about like Charlie Brown having the football pulled out in front of him. That's kind of how this got adopted. So the first one, there is a fee for missed appointments. And I think most doctors have always charged a cancellation fee, but this kind of just formalizes the amount and the situations where that's going to be applicable. So the missed appointment charge is $503.75. This is going to occur if the applicant simply fails to attend. This is going to occur if you failed to set up an interpreter for the evaluation when it was necessary, and so the evaluation couldn't move forward on that basis. It's going to happen if the applicant leaves before the examination is complete. It seems like that wouldn't happen. That happens more often than you would think. They show up, they initially see a nurse or somebody else at the office, and then the doctor's running late. I have had multiple cases within just the last year where the applicant's just gotten up and left the evaluation mid-evaluation. This is going to apply if applicant's more than 30 minutes late and the QME can't accommodate it. It's going to happen if you cancel within 6 business days. Now, one potential option here is if the cancellation fee is incurred due to the fault of applicant or their representative, this is something you may be able to seek a credit for. Now, as we all know, if you've got a settlement that's a low enough amount and you try and take credit for it, oftentimes that's the kind of thing that's going to blow up your settlement. So, your mileage may vary on how much you're able to seek and obtain credits for that. You might be able to get a judge to approve it, but that doesn't mean that you're going to be able to get your settlement through if you actually really push for the credit. Anyway, next slide. Additionally, the physician can charge if they, so let's say the physician produced a record review and the evaluation got canceled at the last minute. If they reviewed records that are over those 200 pages, they're allowed to charge $3 a page for that record review that they produced for a canceled evaluation. Now, one thing that doesn't quite make sense to me about this is if you've got records that are under 200 pages, I don't know why a panel doctor would ever produce that report, because you'd essentially be producing a record review report, and there's no additional money that's in the fee schedule for that record review under 200 pages that would be in addition to the cancellation fee. So I suspect you'd really only see this happen if you had records that were over 200 pages. One other just additional thing here is any pages for that record review report, if it's produced by the doctor, that cannot be rebilled for the next time if a face-to-face evaluation takes place. All right, so next slide. Now, the initial charge for the med-legal evaluation for that flat fee is $2,015. Now, we already know the old flat fee charges were $625 and $975, and those weren't getting used that often. So essentially, this would be every evaluation is billed at roughly the equivalent of an 8-hour ML-104 examination. That's high. I don't know that this, for people who have seen a lot of ML-104 med legals come down the pike to bill review, I don't know that that $2,015 is going to be that much out of whack with the amounts that were previously getting billed on these type of med legal reports. That includes your 200 pages of records, and then, as I already said, $3 a page for any records over those 200. And that, in addition to the flat fee, is really where you're going to start getting into significant increases in your cost. All right, next slide. Now, in addition to the initial report, there's now a flat fee for a follow-up med legal evaluation, and that's $1,316.25. Now, this is a very particular thing. This is a term of art, a follow-up med legal evaluation. It must involve the exact same physician. So if a physician retires and you had to get a new physician, that's not going to apply. The follow-up evaluation also has to be within 18 months of the first evaluation. Now, we know from cases that stay open for a long time, often if you authorize a fusion surgery or a total knee replacement or some other significant treatment, applicant may not get back to that doctor for a lot longer than 18 months. So that follow-up med legal evaluation flat fee is only going to be applicable if they go back to see that exact same physician within the first 18 months. Now, that's also going to include your 200 pages of records, just like the initial evaluation, new records, not the ones that were sent over with the initial. And then again, $3 a page for any records that are over those 200 pages. All right, next slide. And then we come to our supplemental med legal fees. These are only going to be applicable when you ask a doctor to review records that were not previously submitted at the time of the initial evaluation or follow-up evaluation. And you're going to get 50 pages as part of this supplemental report fee. Anything over that, again, going to be billed at $3 per page. So you're going to want to do the best you can to get over all the records that you want the doctor to review at the time of the initial evaluation. Given these follow-up fees and these supplemental report fees, I would make sure that I have some kind of dispute that I really want to have the doctor address at the time of an evaluation before I set these initial evaluations. So I would be much more apt on cases to wait until I'm certain that an applicant's going to be permanent and stationary, and I've got my discovery done so that I'm not having to send out these supplemental requests on a piecemeal basis. Before, sometimes I would get one report or one diagnostic test in and I'd send it over to the doctor because I knew they were going to bill by the hour, and there's only so much you could bill at $250 an hour to review that and produce the report. But now you certainly don't want to have a scenario where you're going to be sending a lot of supplemental requests. All right, next slide. Now, what is not allowed to be charged for as part of those supplemental requests? One, a doctor's not allowed to charge you for a supplemental report that is addressing information that was available in the medical record at the time that the initial evaluation or the last follow-up evaluation was done. And it's not allowed to be charged for things that a doctor was already requested to address. Now, I could see this leading to lots of litigation because there are often times where a doctor would consider himself to have fully addressed causation or apportionment, and I review the report, and I don't think that his analysis of that is substantial. And so I'm going to send him a supplemental report request that asks them to address specific interrogatories regarding apportionment or causation, and that's often going to involve records that they've already reviewed. Based on the way it's written, a doctor could not charge you for that, but that's going to sometimes be pretty significant supplemental reports that they're going to have to write that involve pretty complex analyses that they're not going to be able to bill you for. So I could see that being a problem down the line. Supposedly, a failure to issue a supplemental report at a request due to billing disputes like this could lead to discipline by the administrative director. Again, we'll kind of see where that goes. Now, at this time, I think I'm going to turn it over to Phil. Next slide. And he's going to address a few more of these specifics for you.
Perfect. Thanks for that, Josh. And welcome, everybody. Good afternoon. My name is Phil Hermanson. Some of you may or may not know me. I work primarily out of the San Diego and Riverside offices, so I handle cases throughout most of Southern California, but predominantly between San Diego and the Inland Empire, to include boards of Pomona, Riverside, and San Bernardino. Very familiar with those judges and the people up there as well as a lot of their physicians. I started with Siegel, Moreno, and Stetler about 5 years ago. Prior to that, I was at another pretty prominent defense firm doing workers' comp. So pretty much as a licensed attorney, this is what my bread and butter has been on the defense side. Unlike Josh, I didn't do any of the applicant side. I am in the Air Force. I've been in for about 18 years now. I switched from active to the reserves. I've been stationed throughout the world and lived in multiple different countries, but San Diego's always been home, which is what brought me back here. So without further ado, I'm going to go over some of these additional charges that you're going to see come up with this new med legal fee schedule. So first being, as you can see on the slide, med legal testimony or doctor's depositions, cross-examinations. So they raised that rate to, and now it's just a flat $455 per hour. So basically, you said it, you need to pay 2 hours, so $910. So they did codify when you have to cancel or reschedule that without incurring a fee. Before it was kind of up to the physicians and they'd have all these different policies. But now you have 8 calendar days. So as long as you do it within 8 calendar days, you won't have to pay any fee. If you don't do it within there and you either reschedule or cancel it within that time frame, you are going to have to pay 1 hour of $455 for that fee. They're also entitled to any of their reasonable and necessary time spent related to the testimony, such as preparation or travel time. And that's billed in quarter of an hour increments, rounded to the nearest quarter. All right, we can move to the next slide. All right, review of Subrosa video. So this one's kind of a unique one because they get a bill you separately on top of for the supplemental report that you may ask them to author in connection with this. So the rate that they get a bill you at is $325 per hour of Subrosa video. Now or their usual and customary rate, whichever is less. I don't foresee any physician saying they're going to take a lesser amount. So I would be prepared to pay that $325 per hour. And then also billed in quarterly hour increments, also rounded to the nearest quarter hour. Within their report, they do need to state, they need to verify under penalty of perjury exactly how much time they spent reviewing the Subrosa video. So you need to look for that in there. And also, like I said earlier, if you send it requesting a supplemental, they get a bill you for the review of the Subrosa on top of the supplemental report. Now, if they receive and have received the Subrosa prior to supplemental report being requested for another issue or something to that nature, or a med legal evaluation, whether it be a follow-up or an initial, they need to include that within that, and they don't get a bill you for a separate report. So make sure that if you do have something that you want these doctors to review, bear in mind when you're sending it to them. I know a lot of the times you kind of want to see what the injured worker is going to tell the doctor, see if they're going to catch themselves in a lie or whatnot, and then try to kind of drop it on the physician after the fact. But you want to bear in mind these costs as well. So make sure that if it's the appropriate time, I would send it ahead of time before any reevaluation or any other supplementary request. So you only get to pay 1 fee for that report. Next slide.
Oh, real quick, one thing that I think could be potentially problematic in terms of billing on the Subrosa videos is oftentimes we might only have a few minutes of it that we think is relevant, but the investigator may have hours and hours of footage. And I've ran into applicants' attorneys who insist that all of the footage is reviewed because they essentially say, well, all the footage that doesn't show anything relevant, showing what's relevant is that my client wasn't demonstrating that they were injured or whatever. And so if you've got a case where you've got 12 hours of Subrosa footage and there's really only 5 or 10 minutes that are relevant, you could end up with some pretty significant charges for review of that, just for the couple of minutes that we actually think is going to be relevant. So that could be something that you might want to keep in mind moving forward as well.
Cool. And so now we're going to move into those modifiers that Josh had mentioned, and it's modifiers regarding interpreters and specific types of physicians. This is going to be your psychologist, your psychiatrist, all those other physicians he had mentioned. So with regard to an interpreter modifier, I mean, in Southern California, it's pretty common that we use interpreters quite a bit. That will increase the cost of your evaluation by 10%. So you're going to take that, if it's that initial evaluation of $2,015, you're going to add 10% on top of that if there's an interpreter involved. And then likewise for any reevaluation and such. All right, we can move on. So for AMEs, here's what Josh was saying, and I agree with him in the sense that most of the time the judges want to limit the amount of trials we have or disputed issues. So they do strongly encourage the parties to use an AME. So it kind of limits that what we're actually litigating at the board and all the disagreements. So this one doesn't make a whole lot of sense that they're going to just increase the value of the services by 35%. So it's a 1.35 modifier. Now, also, if you have an interpreter, that increases it by another 10%. So now you're at a 45%. So I do agree. It's going to be one of those things where you're going to want to sit back and consider: do you want to utilize an AME to try to avoid all the likelihood of increased issues to litigate, whether it be a QME versus a PTP, or do you just want to go to an AME to try to get this thing resolved? But you also have to bear in mind the added cost of an AME that's built into it right away. Next. All right, so psychiatric and psychological med legals. So this is where your psych claims come into play. So basically what this does, if you go to a psych med legal, whether it be a QME or an AME, and you'll see below that the AMEs get even more pricey, but it basically doubles the cost of the evaluation. So that $2,015 for your initial comprehensive with the review of 200 pages is now worth $4,030. If you have an interpreter involved, now you're another 10% over that. Now this may or may not be more cost effective because we're used to seeing a lot of these initial psychiatric or psychological evaluations and reports, and it wouldn't be unheard of to see an initial report go for $10,000, $15,000. I'm sure plenty of you in the claims arena have seen those bills. So with regard to that, if you didn't have a whole lot of records to review, this might actually be somewhat of a kind of a break for you. You're only paying a $4,000 bill as opposed to what generally would be anywhere from $5,000 to $15,000, depending on the physician. So, but typically if you have psych issues involved and the person has quite a tattered history and you have a lot of records to be reviewed, it's going to get real expensive real quick because you only get that 200 pages, then you're $3 a page thereafter. So it gets pretty pricey. And likewise, that interpreter modifier doesn't go away. So anytime you have an interpreter, whatever that rate is, whatever modifier, you always are going to add that interpreter one, which will add another 10%. So, and if you're using it in a psych AME, now you're 135% more. So basically, it's 2.35 for the AME, and then with a interpreter involved with the AME, now you're at another 10%. So almost 2.5 times more what the initial evaluation or the cost of the evaluation would cost if you go to an AME and there's an interpreter involved. So you definitely want to bear in mind these costs when you're looking at these psych med legals. And I think Josh has some insight or some thoughts on this as to his strategy with when it comes to these psych med legals. You want to?
Well, so you kind of have to come to a conclusion sometimes on these cases. How much is it worth actually fighting on psych post 2016? Most of these cases, applicants can't get compensable consequence permanent disability on their psychological injuries, assuming that it's a compensable consequence of the pain or the underlying injury. So sometimes you may just want to pick up the case and pay for the cognitive behavioral sessions. I think under the fee schedule, the last time I looked, I think a CBT session was around $125 a pop. So if you are authorized 6 visits for CBT, you're talking $750. Now, you have to still take into account, am I going to owe future medical care on medications for the rest of their life? How long is that likely to drag out? But there's definitely going to be scenarios where you may be better off just picking that up, paying for some basic sessions, considering most of them are going to come back compensable anyway. If you've ever had many psych med legals on these cases, sometimes it may just not be worth the cost, especially if you've got significant amounts of records to be reviewed. You're looking at $10,000 or $15,000 examinations. So that may be something that you just want to keep in mind as a potential strategy on some cases.
Yeah, definitely. And I can foresee an instance where psych starts becoming more prevalent these days. I know when they weren't able to get the add-on for PD or the increased impairment for PD for psych, you saw a lot of applicants turning kind of go away from the psych, sleep, and sex. But I can foresee now with this fee schedule and kind of tying our hands to the cost of these evaluations, I can see it becoming more prevalent that they're going to try to throw it on there as a means to try to leverage a bigger settlement potentially. So
Yeah, I would say that's probably the biggest fallout you're going to see long term from the changes is if applicant attorneys realize, hey, these evaluations are pretty expensive now, especially if I subpoena a lot of records. And they're already encouraged to subpoena a lot of these records because, applicant attorneys have very close ties with some of the subpoena companies. So they are already subpoenaing all the records. And then if you send them to the doctors, now you've got a very expensive evaluation. And if I file for multiple specialties, we've got a very expensive evaluation. So your thoughts on what might be nominal value for settling a case early could be significantly increased now, taking into account for these costs. That could be something that I see as a fallout down the line. Once everybody's adjusted to exactly how much this increases claim costs.
yeah, true. And thanks for that, Josh. So let's move on. And this is those other modifiers that Josh was talking about, the other physicians. So the toxicologist or the oncologist. So, and again, I've been doing this for about 8 years now, and I've yet to see a toxicology panel evaluation occur. Doesn't mean they don't. I'm sure they do. I just have yet to experience one. Nevertheless, if you have a toxicology QME involved and you need to go to an evaluation, and the physician is a licensed or certified as a QME in the specialty of internal medicine or a board certified internist, then their value of their services are increased by 50%. So now that cost of that initial or supplemental is increased by 1.5. So you want to multiply it by that. And then likewise, that interpreter, that modifier doesn't go away. So that'll increase it another 10%. So that'll bring you up to a 60% increase from the initial cost. And then likewise, if you agree to an AME to do this evaluation, now it's another 35% on top of that 50. So it's 85%. And then if you get to, if you need an interpreter involved, now you're at 95%. So almost double the cost of the initial evaluation. And that's for toxicology. And likewise, that's the exact same for oncology. They would either need to be same, a certified as a QME as an internist or a board certified internist. And those rates will be the exact same, 50% if it falls under that category, 60% with an interpreter, 85 as an AME, 95 AME with an interpreter. And then also, so if you ever get to a point where the judge orders you to an evaluation, now the judge gets the discretion as to what modifier they're going to assign to it, whether they assign it as an AME, and this will be in your cases where they order you to an IME because they don't find any of the reports persuasive or they just can't make heads or tails of it. So they order you to that independent medical evaluation and send you to this physician. They get to decide which modifier to use. I would imagine that they would probably go with the AME rates. However, they have discretion here, and I can see an instance where if they try to go too crazy with it, such as like assigning for an orthopedist to do double rate like a psychologist or something, then you probably want to challenge that because that just wouldn't make much sense. But either way, that'll be as it comes up. So you just want to make sure that you're paying attention to that and make sure that your counsel, whoever's down there at the board, if you do run into this instance, I would be pushing for the lesser of the modifiers, trying to keep it as minimal as possible. All right, so let's next slide. And finally, those declarations. Always remember these declarations. These are very important because if you don't, it's going to give the doctor an opportunity to potentially not review anything that you've sent him, do the evaluation, issue a report that gives you nothing to work with, and then you have to send him this declaration and wait for a supplemental and get charged for that supplemental. So this new fee schedule includes specific page allowances. Like Josh said, it's $200 for your initial or reevals that occur within 18 months. Basically, any in-person evaluation, you get 200 pages included with that. Now, if you're doing a supplemental request, and this is where you want to be mindful of what you're actually requesting from these doctors, you don't want to just get one report and then send it off to the doctor and say, hey, issue a supplemental report, because now you're getting billed for that per report. So you want to be mindful of what you're actually sending to the doctor and when you're sending it. So you want to try to compile as much together as possible and send it as one fell swoop, so you can limit the amount of supplementals you're requesting. But anyways, with the verification, so the physician also has to verify under penalty of perjury the amount of pages he's actually reviewed. I would envision a scenario where the physician's going to say, you sent me 282 pages. I reviewed 282 pages as part of this evaluation. That's what I envision happens, but make sure that that's listed in it should be in the report. So.
Yeah, one thing to add, I think traditionally on most of these med legal evaluations, the doctors have not really done the record reviews in my experience. They're done by somebody else on staff. And if I read these regs with the verification, the doctor's supposed to be reviewing these records now. If they're, especially that's part of the $3 per page part of it. So I would hope that would lead to some higher quality med legal reporting where they paid more attention to those records, but who knows whether that actually ends up being the case.
Yeah, so the reg, I think it actually states that a physician must review. So I still foresee that they're going to get their summaries from their people, probably make their life easier. And I wouldn't be surprised if the doctor literally just gave it a kind of a thumb through to say, yep, I reviewed them all, looked accurate to me. I don't ever foresee an instance where a doctor's not going to say they didn't comply with this, but keep an eye out for it. You may catch them, off guard and be able to try to challenge that aspect of the billing. But again, just make sure you're on the lookout for that. So, and next slide. And this is what we need to do. So as claims handlers, as attorneys, whoever's involved and whoever's compiling these records and actually sending them off to the physician, this is what we have to do. We have to include a declaration saying not only that we complied with 4062.3, which is we served this on the opposing counsel or on the applicant, gave them so long to object, and here's what we're giving to you, doctor. But we also need to provide an attestation saying exactly how many pages. Now, what's included in that pages does include the cover letter. So what I would highly recommend is that you go through all of your subpoenaed records are going to be one of your biggest, especially when it comes to records from like Kaiser or whatever. So when we go out there and start subpoenaing, every record under the sun that we can identify, whether it be in a medical canvas or through deposition, whatever it is, or we see a note through another record that leads us on this trail to get more records, you're going to want to really comb through those with a fine-tooth comb and make sure you're only sending stuff that's actually relevant to your claim. So if you're dealing with a guy that has, a right knee injury, you're probably not going to want to send records that involve a head cold or stuff like that. Whereas before we would kind of just say, here, doctor, here's 800 pages from Kaiser. There might be a handful of pages in there that may be relevant to this, so we're going to want some apportionment. You're going to want to comb through and actually only pull out those relevant pages. Now, the problem you're going to run into is with applicants' attorneys who are not trying to make it any easier for us or make this less expensive. They're gonna want to say, well, he needs to see all the records, or it's not going to be substantial medical evidence. So, and I've already run into this with a couple attorneys already, where they've sent me their declarations, and it's like 1,400 pages. And I start combing through it. I'm like, why do you need to send dental records on an ortho claim? It makes no sense. So I called them and said, hey, if you're not agreeable to take out all this, then I'm just going to file for a hearing and we can go to trial on what's actually relevant, what needs to be seen by the doctor. I think at the end of the day, you need to determine what's relevant, what should be seen by the doctor and reviewed. So there's going to be a lot more of that initially, especially early on. I think as time progresses, as more defense attorneys start forcing these applicants attorneys who don't want to be reasonable and say, well, I'm just going to send the whole, the whole kitchen sink because your client's going to pay for it no matter what. I mean, that's once you force them to trial and have to go through page by page and say, hey, why is this relevant? Have them explain that to a judge. I think when they realize they're not getting paid to actually litigate this, they may put the onus on us to say, fine, you tell me what's relevant, what's going to be sent. If there's something else that I really see that I need this doctor to see, then I'll let you know. But I think eventually we'll get to that point. But initially, I do think there's going to be a lot of litigation, or at least a lot of initial hearings involving what we're actually going to send to these doctors. You want to make sure you're taking out all of the cover pages. You don't want fax cover sheets. Basically, you want to make it as bare bones as possible and only send what's truly important to these doctors. On an admitted claim where you're not disputing injury and there's really nothing significant for the doctor to look at in a deposition, you may not want to send that 50-page deposition. So you want to be mindful of these things and actually take a step back and start looking at those types of things and say, do we actually need this doctor to review our deposition transcript? Is it really necessary? Is there anything of importance that he needs to see in it? Clearly, if there's inconsistencies in what the applicant or injured worker is telling the physician and what he testified to, then maybe you want to send that deposition for a supplemental report and say, hey, looks like this guy may be lying to you or telling you something completely different. Their credibility might become an issue at that point. But so you really want to go with a real fine-tooth comb. And this is where it's going to get a lot more burdensome for us, for the claims examiners, to have to actually go through all these records. Because, I mean, Josh, I'm sure you can attest to, when you reviewed subpoenaed records before, you weren't necessarily reviewing and saying, all right, only these 3 pages are, I mean, you were just kind of reviewing for their substance and what's in there. Is there anything that this doctor might be able to catch, right?
Yeah, obviously, I've got plenty of cases where I'm now looking to send records to a panel doctor, and I've already reviewed subpoenaed records. And when I reviewed the 1,500 pages of records, I was taking a note on the pages that were relevant to a specific body part or whatever, but I didn't necessarily make a page range like, hey, the doctor goes on to talk about all of the back for the next 30 pages, and then the next 120 pages are irrelevant. I'm going to probably have to start doing that. One of the things that you're going to have to keep in mind too is every page that you include gets billed for. So if you include a cover page, a fax page, a proof of service, all of these documents that seem like a doctor shouldn't be reviewing them, don't include them. You're going to get the $3 per page charge for all of that. I suspect if you send over a report that has a blank page in it, if it's listed as a page on that sheet, they're going to bill you the $3 for that page. And if you sign the declaration and the verification for it, they probably should bill you the $3 a page for it. What I've been doing actually recently is I've just gone very directly to clients and said, hey, I know that you have bill review. I know that some of this stuff might not be something that's in your billing guidelines. There's 3,000 pages of records. I know that the applicant had prior injuries that are relevant to our particular case. If we send that over, that's $9,000 to be reviewed. Here's my billable hour rate. I also have a paralegal on staff. Here's their billable hour rate. Are you willing to authorize my paralegal to go through and review and remove all the irrelevant records? And so far, I've been having authorizations from clients to do that. And actually, just in the last day, I had a case where there was I think 1,215 pages of subpoenaed records from Zurich American, and my assistant reviewed them and they were removed down to 298. So you're talking about a reduction of nearly 1,000 pages out of that, which is $3,000. And I think it took her like 3 hours to do it. And so there was probably a savings of around $2,700 or something around that line to have her do it as opposed to just sending everything over to the doctor. And I know that if you're a busy claims adjuster and you've got 150 cases plus that you're looking at and that you're processing, this is not something you want to sit down on your time to do. And frankly, I don't really want to do it myself either. I don't necessarily have time to do this on all of my cases. I'm too busy doing legal work on the cases, but it is something that you may want to keep in mind and get creative with, because the amount of savings that you could have would be would be crazy.
Yeah, and so we can move to the next slide. All right, and this just goes, okay, so this is another important topic. So for what we're sending, now is, and this really comes into play with a lot with the deposition transcripts. So questions come up quite a bit, and it's actually in the regs. If you were to send a condensed copy, so now that 50 pages, only about 13 pages, if you send it as a condensed copy, when it has multiple pages on one sheet, they're billing it individually. So if there's 4 pages per sheet, you're getting billed as 4 pages. So that's not going to be a way where you can try to kind of sneak your way around by putting multiple pages on a and kind of minimize it that way. So you got to make sure that when you're sending stuff, you actually want the doctor to review it. Now, if you have a newer claim, not a whole lot's gone on, you're just going to a compensability exam and you don't have a whole lot of records, sure, maximize your 200 pages, get them to review all that stuff. Then you can get it done early. But all right, we can move on. All right, so Josh, do you have anything to add? That's the end of our actual presentation. So we're going to be sticking around for any questions you guys may have.
Yeah, I was just going to add, we were kind of chatting before this about other creative ways rather than just reducing the page count that you might be able to use to avoid some of these med legal examinations and the costs that come from them. And one thing that I always encourage with my clients, if you've got a doctor who's treating applicant in their MPN and they say applicant needs a neurological consult, I'll often see that gets sent to UR and UR says neurology is not a compensable body part and it gets denied. Well, at that point, you've just given grounds for a med legal panel because you've disputed the compensability of that body part. Generally, consults aren't considered to be something that should be sent to utilization review because it's not treatment. So I often encourage my clients, if you get a doctor who says this person needs a neurological consult or an internal medicine consult, just go ahead and send over administrative authorization for that if you're allowed to, and see what the doctor in your MPN says. And maybe you can avoid having to actually go through the panel process for that body part, and you can keep it with a doctor that in theory is within your MPN, so you have a little more control over what you're being billed for. You may still end up at a panel on that case down the line, but you might not. And so that's one potential way that you can avoid just immediately sending out, oh, we dispute that body part, and giving applicant's attorney grounds to immediately seek a panel. Because if you send a denial letter for that body part, a judge is going to order a med legal in that specialty every time if you go down and litigate it at the board.
Well, Josh and Phil, thanks so much for that awesome presentation. We do have a number of questions from the audience. If you'd be so kind, is that okay?
Yeah,
Sure.
shoot.
All right. So the first question that we have is recently several PQMEs have asked me to sign a stipulation that they can bill an ML 104. Is this ethical or should this practice be reported? If reportable, to whom should it be reported to?
Well, there's no longer an ML 104. It
Yeah.
doesn't exist in the regs any longer. The
Well,
billing fees are now, I think it's 201, 202, and they're those flat fees. So I don't think you'll ever see that again. So at this point, that's just kind of become irrelevant because they're, for any evaluations, reports, anything after April 1st of 2021, an ML 104 doesn't exist any longer.
Now, when you said recently, I mean, has it been since this new fee schedule's been enacted, or, and then also, are they refusing to see the or evaluate the applicant or author report? Because if so, yes, it is reportable, and you'd want to report that to the administrative director. So, but yeah, I mean, kind of need a little bit more info on that as far as when they've been requested. But yeah, it's like Josh said, it's no longer in existence. This is the new fee schedule, so it just sounds, yeah, I'm not 100% certain.
Yeah, and I mean, literally, that billing code doesn't exist anymore. It's now a 201, a 202, a 203. So the old 102s, 103s, 104s just aren't even in the regs any longer.
Great. Thank you. Here's the next question. Can we hold our employees accountable for missing an appointment, or will it look like retaliation?
Well, It depends on what you mean. You can seek a credit potentially against settlement for the amount of that missed examination, the 503.75 or whatever the charge was. I generally never recommend retaliating against your employee because they missed the panel evaluation. Anything to do with workers' comp and the actual administration of your workplace, to the extent possible, should kind of be kept separate from one another if you want to avoid issues with 132As.
Yeah, completely agree with that.
Next question. Do medical appointments have to be canceled in writing?
It's always a good practice. I don't think it's actually codified or written in the regs. I've kind of dug around trying to find that. But you definitely want to ensure that you are notifying everybody and copying the doctor's office that it's being canceled. The last thing you want is to have another issue that might be something to litigate at the WCAB, where you're going to spend $1,000 or more litigating this issue that you may prevail on, but to save $500. So it's always a good practice. If you're going to cancel something or reschedule something, especially if it's within that time frame, do so in writing. That's the best practice I can recommend.
Well, and as a side note, and I'm sure that we all think that it shouldn't work this way, but human nature says if that doctor is going to then evaluate applicant because there was a cancellation fee and you get into a dispute with them about the cancellation fee, you may be less apt to get a favorable report from that doctor at a later date. So, I mean, just human nature, you want to pick and choose your battles sometimes.
Next question. Can the applicant attorney argue that a report is not substantial medical if they agreed to the records that were sent?
That's always an issue that, I mean, that's determined by the judge. I mean, you can always argue a report's insubstantial for one reason or another. I mean, that's something that a judge makes the call on. I mean, I'd like to say, my word is the gospel here, and I'm right all the time. But guess what? The judge gets to make that call as to whether it's substantial. So if you have, if there's certain records that have zero relevance, for instance, the case where I ran into where they were trying to send dental records for an orthopedic claim, like, it bears no relevance. Why would that even matter? So I don't think that argument's going to work for them if that's the aim of it. But I think every case is going to be unique in that regard. But again, it's always an issue for the judge to make the call on. So.
Yeah, you can argue it. Whether you'll be successful or not, that's a different thing. My girlfriend asks me all the time, can you sue for that? I said, you can sue for anything. You just might not win.
True.
Hey, that's good advice. No, I'm just kidding. We have just about 5 more questions left. So let's go rapid fire here.
Oh.
How easy would it be to object to records that are not necessary?
Just simple, shoot off a quick letter and say, hey, and pick up a phone and call them. So pretty easy. But if they don't agree, it's a dispute now, and you need to go to the board and address it. So
yeah,
I recommend if you're doing it, if they don't answer or respond to you immediately, I'd give them a call, wait a day or two, just file a DOR on the issue. That'll generally get a response from them.
Yeah, the 4062.3, the declaration that you're signing that you essentially coordinated with the other side, I don't think anybody's really going to want to sign something under penalty of perjury that says that you reached that agreement with the other side if there was no agreement. So essentially, if you object, they shouldn't be sending those records over at that point because you've got a dispute and they can't sign that declaration under penalty of perjury any longer.
Yeah, so it just move the eval likely if you guys can't come to a prompt resolution.
Great. Here's a 2-part question. Is the declaration and verification the same thing? And in the declaration, do you only count the actual records, or do you include a cover letter?
Includes everything, your letter, all of it. Declaration verification. Well, the attestation is saying how many pages it is. Your declaration is you saying under penalty of perjury you've complied with 4062.3, so that you've served them, you've waited the appropriate time for them to object. No objection was received. Here you go, doc. So most people will probably put it on the same page and sign it. That's how I do it. So
I don't know if the question is asking. On my declaration that I signed that we properly complied with 4062.3. I list the number of pages. There's also a verification that the doctor signs that they reviewed those pages, and that's a different document that we don't have any part in dealing with. That's for the doctors.
It'll likely be included in some of the stuff they put at the end of their reports, saying that they didn't violate 139.3 and all that stuff. So I would imagine there's going to be another paragraph saying that. So
great. If one only sends 100 pages for the first report, and then we need an additional report and send 90 more pages, are we within the 200-page limit? In other words, the first 200 pages are covered under the exam flat fee. Is that correct?
Not necessarily. It's at the time of the evaluation, what you submitted at the time. So it's kind of, you get one shot to get that initial 200 pages. After that, if new records come available, now they weren't available to the physician for his evaluation technically. So now he would be authoring a supplemental. So you'd get 50 included with that cost of the supplemental. Every page thereafter would be $3 a page. So
yeah, you don't get to bank pages for future use.
That'd be great, though. I like it. But
I like the frame of thinking. Yes, absolutely. And this sort of goes along with that. The next question says, can we send small font records? Is there a standard for font size on record size to minimize or maximize page count?
Not that I've seen, but if most subpoenaed records that I've seen come already in a format, from a subpoena company or whatever. They're going to be in whatever format you got them from Kaiser or, Sharp Hospital or whatever. And so you're not going to really be able to fiddle with that. You certainly can't reduce it to the point that you cram 4 pages onto one page. That's going to be exactly like the deposition transcript, where if it was 4 pages originally and you put it on one page, it's still 4 pages.
Yeah, I mean, they define what a page is, but I don't think it goes into the actual font size, because it talks about it's just basically an 8.5 by 11 page document. So whatever would be included on that. But I don't think you can, I mean, one, you're not going to be tampering with subpoenaed records and modifying them for yourself. Yeah, so.
Yeah, and if you meet a cover letter and you just want to change it from 12-point font to 9-point font, I mean, you probably save a page. I don't know if those $3 are worth making the doctor's office mad that they have to read something in like 7-point font with a magnifying glass.
Agreed. Yeah, I don't know that you're going to get a whole lot from doing modifying the font. And like Josh said, you're hoping that these doctors aren't going to have kind of a chip on their shoulder when they're writing the report that may impact your liability. So you probably don't want to try to short them by $3 or $6.
Makes total sense. That's good guidance. We're down to the last question, guys. So I am including, this is from someone in the audience stating, I am including the attestation as a page. Would you recommend this?
So I slap the attestation right at the front and I include everything behind it. I'm not, Josh, are you aware that we need to include that as a page for it? I think that's basically the way I look at the attestation. That's kind of our receipt. We know exactly what the cost of that report should cost, and there shouldn't be very much deviation. We know if there's an interpreter involved. We know if it's an AME, a QME. We know the specialty. So if it doesn't apply with any of these other modifiers, I mean, when you're saying I'm sending you 300 pages, well, now you're saying, well, okay, well, the report's going to cost this, but with your eval, the extra 100 pages is going to be another $300. So it should be this plus this. That should be my bill. You shouldn't be surprised when you're getting a bill, like sometimes you would be before. So
I actually think I had this dispute come up with the doctor last month, and there was nothing in the regs that I found that specifically addressed it. It doesn't mean that it isn't there and I didn't just miss it. But yeah, for the purposes of this, I wouldn't count the attestation page or the declaration to be your 300 or your 201st page or whatever. But yeah, I mean, I wouldn't be shocked if you had a doctor who billed you for that page and you ended up with your extra $3 on the report or something.
Yeah.
Well, Josh and Phil, thanks again so much for such a great presentation. Very thorough, a lot of very positive feedback on the comments. If you have a moment to browse through them here before we log off, please do. I'm sure you'll be really excited to hear what people think about it. By the way, to the audience, this presentation is being recorded and we will be posting it online for on-demand viewing very soon. A link is going to be emailed to each of you. Also, please be advised that California adjusters will be receiving their CEU credit certificates within the next 24 to 48 hours. So please hold tight for those. And once again, for Work Comp in Motion, we would like to extend a great big thank you to all of our sponsors that you see on your screen for today's webinar. This event would not be possible without their support. So if you have a moment, take some time to show them some love on LinkedIn or on your favorite social media outlet. You'd be surprised about the difference a kind word can make. So definitely take the time to say thank you to them. And now the moment we've all been waiting for, virtual drum roll, please. It's raffle time. So if you see your name on the screen, I realize it might be a little small. I will try and read them here. Eduvi from Ames, April from Isis, Bill from Sedgwick, Yadira from Paloma, Dolly from Legal Analysts, Jose Gomez from Falls Lake, Jean from Markle, Yolima, Chad, Gabriel Rodriguez from CISC, Charlotte Patente from UPS, Josh, Vince, Kathleen, Cynthia, Jason, Susan Erickson from Gallagher Bassett, Linda from ICW, Rob, Lisa, Dennis, Elizabeth, Mandy, and Sabrina Darcy from Athens. If that is your name, please be on the lookout from an email from the corresponding sponsor that will be reaching out to you to give you instructions on how you might be able to claim your prize either today or tomorrow. For everyone here at WorkComp in Motion and our esteemed panel, we want to say thank you again for joining today's presentation. We hope you have a wonderful rest of your day, and we'll see you next time. Thanks so much, everyone. Hasta luego.
Thank you. Thanks for
Thanks,
listening
everybody.
to us.
Hopefully next time we could be in person and actually see each other. So face to face.
Yes, sir.